All right. We're just waiting a couple more minutes for everybody to join. And for those of you who are already here, welcome. And thank you so much for joining us today. I think we can probably just wait one more minute. We prepared a very exciting webinar today that I hope will be super informative. All right, then I think we can get started. Well, I'm super excited that you're all here with us. My name is Susanne. I am the co-founder and CEO of Citruslabs, and I'm joined by Heather Bustos, owner and partner at Bustos Law Group. As always, quick overview in terms of content. This webinar is all about the new FDA regulation, MOCRA, the Modernization of Cosmetics Regulation Act that was passed last December. And we'll talk about implications of these new regulation for brands. We'll discuss what you need to know about reporting, manufacturing, what a responsible person is, and also go into marketing and claims under MOCRA, and also talk about potential legal consequences when MOCRA isn't followed. And then we will also leave some time for you, the audience, to ask questions. And for your questions, please put them into the Q&A field in Zoom, or you can also put them in the chat. All right, so before we start, I quickly wanted to introduce Citruslabs. Citruslabs is the fastest growing provider of clinical studies for brands. We work with a lot of brands in the health and wellness industry and obviously cover cosmetics, but also work with supplements, superfoods, and also devices. And world-class brands such as Hum Nutrition, Say Beauty, Your Super, and A System are our clients. Our mission is simple. Our goal is to elevate brands with affordable clinical studies to then create research-backed product claims that drive business growth. All of our studies are customized, and you can outsource the whole study to us from start to finish. Now, enough about Citruslabs. Heather, please tell us a little bit about Bustos Law Group.
Well, first off, I'd like to say good morning. Welcome to everybody. Thank you, Susanne, for having me again. These webinars are the highlight of my month. I've really enjoyed presenting this. So as she said, my name's Heather Bustos. I'm the managing partner of Bustos Law Group. We are compliance counsel for brands on a mission. So we help brands regulated by the FDA to support their driving mission. These brands include food, supplement, cosmetic, and medical device companies. We help everyone from manufacturers and distributors to brand owners and importers, so kind of across the supply chain. We do things, some of the services we provide are label and marketing reviews, GMP or quality compliance, registrations, recalls. So we do help people who are trying to not get into any trouble with FDA, but also if you have gotten in trouble, no judgment, we're here to help as well. So we do provide all of those services. And also we've started to provide some mission-based certifications, things like organic, cruelty-free, NSF certifications, just because we've had a lot of demand for it. I've been in business for about 6 years now, and we have a team of consultants and attorneys that are either former FDA or have been in these industries over 10 years. So we have a great team, to help any of these companies in these different areas. Thank you so much for having me, Susanne.
That is so awesome, and great to hear about all of the certification, because I know a lot of brands are interested in organic, cruelty-free, and it's awesome that you also do NSF. Yes. All right, so let's talk about why we're all here today. Can you tell us what MOCRA, the Modernization of Cosmetics Regulation Act, actually is?
Sure. So MOCRA, or Modernization of Cosmetics Regulation Act, the mouthful that is, it's one of the largest sweeping changes to legislation of cosmetics in 80 years. So this is a massive change to the industry. I can tell you personally, doing consults prior to this coming out, a lot shorter, they're going to end up being a lot more in depth and deeper because there's a lot here to digest and to understand. So MOCRA is the legislation, and then the FDA is the agency that is then going to create the regulations to kind of flesh out those rules. So that's what we're kind of waiting for at this point. We have the legislation that Congress passed in December, but now we're waiting for FDA to start promulgating regulations. The first little gold nugget I wanted to give you guys is there is an opportunity for industry to comment on proposed rules. So the way that FDA creates regulations is they come forward with a proposed rule. They allow industry to comment, and also the public to comment on the rule, and then they create a final rule. So if you're interested in, providing your opinion on some of these things, I think that that would be a great opportunity to provide some comments to the FDA when these regulations do roll out.
Wow. So basically, if some of the brands might find some of the regulation, not very fitting for their industry, they can actually comment and collectively maybe even change this new regulation.
Yeah, there's always a possibility. All regulations are required to go through that process. And so I think it's a good idea to provide comments, because the FDA does take those comments into consideration, because they're asking a lot of industry experts and consumers who have different perspectives maybe than the agency could have anticipated.
That's super interesting. Very good to know. That's a really good nugget. Awesome. And now looking at, this new MOCRA regulation, we have reporting of serious health events, we have mandatory registration, and a lot of these things, mention a responsible person.
Yeah.
Can you tell us a little bit who the responsible person actually is?
Yes, so it will depend on how the supply chain is set up, and essentially it's going to be the name on the label is what we're kind of anticipating, is that's what it's going to be. But the name on the label can vary, right? Let's say you're a manufacturer who also owns the brand, so then your name would go on the label, right, as the manufacturer, also as the distributor. There's also situations where the distributor may be the person on the label, and that becomes the responsible person. So it's really important now to understand the connection between what's on the label and who's actually going to be responsible for these requirements. Things like adverse event reporting, what FDA wants to see is whoever's listed on that label is going to be providing a phone number. They've also upgraded to a web address now, which is great. And so essentially that contact person is going to be the person that takes in the adverse event reports. And so you have to have a structure for that, right? You have to have your form on your website. You have to have a person internally that's taking these in, sending it to your quality department. So there's going to be quite a lot of responsibility that comes with the term responsible person. So, we definitely don't want to take it lightly.
Okay. And, responsible person, you mentioned supply chain. Yeah. Brands that don't manufacture, do they also have to comply with all of this?
So different parts of MOCRA will apply to different entities in the supply chain. For example, the registration piece, which everyone's talking about and a lot of people might know about. Up until this point, it's been voluntary, but now it will be required. Actually, in December of this year, by December, you should be registered according to the legislation. I don't know if they're going to be able to stick to that goal, but that is what the legislation says. And so registration is really primarily focused on manufacturers or processors. packagers are included in this. So if you're taking something from a bulk and you're moving it into a smaller consumer size package, you are then considered a manufacturer as well. I call it a pseudo manufacturer, but you're a manufacturer according to FDA. You will be required to register. But then things, like I said, like adverse event reporting or the labeling requirements, that can fall on different people depending on how you have your supply chain set up. So if you are a brand owner and you're designing all your labels and you're responsible for compliance, then you're going to be, you know, the one that has to comply versus the manufacturer who may have to comply with other things. So it kind of just depends on how the supply chain is structured.
Wow, that is very interesting, and no wonder that we are all able to comment, because all of that sounds very complex and a little arbitrary.
Yeah, and it's still very early, right? Like this
Yeah.
just passed in December. It's even for people like me in the industry that are trying to, like, kind of condense all of this down. It's going to take some time, and we're going to have to see a lot of work from FDA. They're busy working behind the scenes right now. They're absolutely swamped from what I've seen, trying to get all this in line.
I believe that.
Yeah.
It's a big change, right? And
Yes, absolutely.
going forward with the new regulation, we are also looking at safety substantiation, good manufacturing practices, allergen labeling, recalls. So I think we should start probably with good manufacturing
Sure.
processes. What does that actually mean? And what do brands need to do to ensure good manufacturing practices?
Sure. So good manufacturing practices on the cosmetic side, it hasn't been a requirement, but it's kind of been implied or insinuated. So FDA, the standard was, they kind of gave you the end game, right? They said, just make sure that your products are not adulterated, they're not contaminated in any way, but they didn't really give you a game plan on how to accomplish that. So CGMPs or current good manufacturing practices are going to flesh that out. They're going to give industry a little more structure on how to accomplish that with rules. It's still going to be vague to an extent, because different facilities are going to function differently. FDA writes them a little bit more vague intentionally, and they leave it up to industry to kind of do what fits best for their facility. So the FDA is now going to codify or create regulations similar to what you see on the food and supplement and OTC side, where, like I said, the rules are going to be more clear cut. In the past, FDA did have a guidance document that was titled Cosmetic Good Manufacturing Practices. Guidance documents are not law, so they're considered advisory and not binding. So it was something that industry could use in the past to kind of get to that end game. Now what we're kind of anticipating is that FDA is going to maybe use some of that guidance and some of the language from that to now, create the regulations. So if we're trying to predict in some way how that's going to flesh out, it's going to be, like I said, that guidance. We've got ISO standards, we've got EU guidelines. The Personal Care Products Council came out with an assurance guidance. I believe that was last year. So there's a couple of things they can draw inspiration from, but I think that we're going to see something that's along those lines. Currently, the rules are not required to be, that proposed part is not required to go into effect until 2024, and the final rule not until 2025. So until then, we're kind of in the dark about how exactly it's going to play out. But it is a good idea to start trying to figure out where you might have gaps and use those examples I gave to get an idea of kind of where you think FDA will want you to be.
Okay, so we should look at the ISO standards, the EU guidelines. I would assume that the EU guidelines are probably the best ones, because typically EU has super strict guidelines for everything.
Yeah.
Yeah.
Tend to be higher standards. Absolutely.
Yeah.
And like I said, that's just for inspiration. I'm not saying that's exactly how it's going to come out, but I think it's a good idea to kind of look at those and see, what they've done. A lot of industries already kind of doing a lot of this. They're raising the bar on what FDA had required, but it's still a good idea to do a gap analysis of what you currently have and try to compare and see where you might have any gaps in your quality.
Awesome. Okay, so looking at the gap so that we're all ready until final rule comes out in 2025. And maybe there will be some changes happening right before that even. Okay.
Yeah.
So next topic is FDA compliance. Are brands automatically FDA compliant, whatever that means, when they follow MOCRA?
So first of all, currently MOCRA in its state as just legislation, it's hard to really, like, from a practical sense, say that if I follow MOCRA, I'm compliant, because we just haven't seen the regulations flesh out yet. So for instance, let's say on registration side, right now you have a voluntary registration. So if if I go in and register myself in the voluntary database and list my product, does that make me compliant with MOCRA? We don't know. It may end up being a totally different database. FDA may charge fees. Like we don't really know how that's going to flesh out. So I think it's a little too early to even ask that question. But let's say hypothetically the regulations were all out there. There are some things to consider in addition, and I'm saying this because it's come up a lot, with my cosmetic clients. Just because you are compliant with cosmetic regulations doesn't necessarily mean you're compliant with any other regulations that may apply. So an example is a cosmetic that's also a drug. So if you have a sunscreen product, anything that has an SPF claim, if you have an acne product, those are considered can be considered cosmetic and drug combinations. So you also have to comply with the drug regulations in that case. So it's always good to look at it holistically and not kind of just box yourself in, and make sure, that you're looking at how your product is regulated across the board. Always look at the intended use of the product, and then kind of figure out what category you may be fitting in. And then you can determine, what regulations are going to apply.
Okay, so that is good to know. So even if I have just a moisturizer with SPF in it, then I can be considered also a drug apart from a cosmetic.
Absolutely. Okay.
Okay.
So it's important, to look at both. There are quite a few. That's usually where you see the crossover, is drug and cosmetic. You're not really seeing like cosmetic. There may be cases like mouthwash, for instance. Mouthwash can be a cosmetic as well. But it can also fall in the drug category. That's something you may not have even considered, but those are some examples of those very like specific situations where there may be crossover between the two.
Yeah, I would also assume that probably many brands that want to make claims also around acne. You mentioned acne before.
Yeah.
They might not be a drug from, ingredients, but then probably go into the realm of drug product claims, correct?
Yes, absolutely.
Yeah.
And the difficulty with drugs is I tell my clients it's like a cliff. It's like you have these OTC drug monographs, which are like so specific, like you can't do anything innovative in that space. And then the only other option is a new drug application. Like you're going off that cliff. You're spending millions of dollars. You're taking years. Like there's no like middle ground currently. And so it's really, really important that if you do have any products that touch on that drug side, that you really do a good analysis of whether it fits in that OTC or the new drug application category. Okay.
And then one thing that is new is the mandatory safety substantiation. What is that? What do brands need to do?
Yes. So this was already kind of something that FDA wanted to see was substantiation. I think it makes sense, right? You can't just throw something on a product, a claim on a product out of thin air. Like it needs to be supported by something. It makes sense, right? But basically FDA, I think really this is them signaling there's going to be a ramping up of enforcement with safety substantiation. And they're kind of looking at it, this like dossier concept, which essentially is you're not necessarily submitting directly to FDA. You're keeping it on file as a dossier so that if it is requested, you have the documentation on file. And, you know, there's going to be some records keeping requirements as well. Like I said, in the dossier, you got to make sure that you're keeping the records. This can be on anything from, depending on the claims that you're making, from your ingredients. So you want to work really closely with your suppliers. It can be on your formulation as a whole. And then there's different levels of substantiation based on the types of claims that you're making as well.
Okay. So basically, if I want to make claims, then I'm keeping a file, a dossier file that has substantiation behind it. I am not submitting that, but in case that the FDA wants to see some form of proof, then I can show them my documentation.
Right. That's
Okay.
the understanding at this point of what the law is requiring, is that you keep the substantiation on file. So it is mandatory. And it's funny, I kind of took a little excerpt from what's considered adequate substantiation, and it's leaving so many question marks, right? So I'm going to just read it. I know it sounds a little boring. I'm going to read it real quick. Tests or studies, research, analysis, or other evidence or information considered among experts qualified by scientific training and experience to evaluate the safety of cosmetics and their ingredients, sufficient to support a reasonable certainty that a cosmetic product is safe. Like, okay, what does qualified expert mean? What does reasonable certainty mean? All of these things are going to have to be fleshed out in a guidance document. I don't see it any other way. So again, FDA tends to leave these vague on purpose, but then we're going to need to see something to kind of help us out here, right? Because being able to apply that is going to be a little difficult.
Yeah, I would assume so. It also obviously then also comes down to, you know, that brands needs a huge budget to get started in the first place. But we'll talk about that a little later.
Yeah. And if we're talking about safety, because that's really the focus here, is like the safety substantiation, not necessarily claims. We kind of dipped into that a little bit. But on the safety side, the safe definition is not injurious to users under conditions of use. So here's my nugget for this one: is directions are going to be really important. Being able to really consider how consumers are going to use this product and the dangers associated with it. Making sure that your ingredient suppliers have safety substantiation. Start talking to your suppliers now. If they're not on the same boat with you, start finding new suppliers. This is going to be really important. If you are an ingredient supplier and you're on here, start working on this. If you don't already have substantiation, make sure that you get that started. So those are kind of my nuggets regarding the safety substantiation. And I think these are the things that we need to start considering, you know, if we're going to start preparing for the enforcement of this.
Yeah. And then also speaking about ingredients, currently there has been a lot of buzz around mold in clean beauty products. And, you know, obviously some of these products might need to be recalled. And then recall is also defined in MOCRA. And what is a mandatory recall, and how is this currently handled, and what is changing for brands?
Right. So like you said, recalls in the cosmetic space tend to be around microbial growth or contamination. That's usually the reason for recalls in this space. So I would be really concerned with making sure that you're testing your products, you know, really thoroughly. You're using, you know, good. If you're using a third-party lab, you're using one that's been audited. The FDA had essentially, they now are allowing, you know, recalls are now mandatory. And so this is in the case of where there's a serious adverse health consequences or death. The standard FDA is using is a reasonable probability. So again, a little bit vague, but it kind of leaves them with room to determine what they feel is a reasonable probability that the product will cause the serious adverse health consequence or death. And then in the case where a reasonable person, we're going back to that, refuses or does not voluntarily recall, the FDA can order an FDA order can require immediate cease of distribution. So this is a very big change from in the past. And what the FDA tends to do, which is what brand owners hate, but this is how they get their way, is they publish it, they make it public. When you see, it going across CNN that there's a, contamination of some sort, or you see it on different news channels or whatever on the TV, newspapers, that's because FDA has done a press release to notify the public. So yeah, I think it's important that let me think about how we can kind of help in this situation. One, make sure that you're taking in your adverse events. So come up with that system, like I said in the beginning, where you have a form on your website and you have a person that's fielding these things so that it comes through you first. You're getting that information first. It's not going direct to FDA, so that you can then sit down with your quality team, with your, in-house counsel or your attorney, go through, okay, do we need to do a recall, so that you're making that call, not FDA making that call. I think that that's going to be, something really important that could help brands to avoid, all the publicity and everything that comes with a recall.
Yeah, kind of doing already internal damage control, right?
Exactly.
Yeah, that's awesome.
Yeah. Mm-hmm.
And then, we talked about it a little bit already with all of these new guidelines, regulation. As brands that are just starting out, this can also mean huge investments and a big barrier of entry. And are there any exemptions for small businesses in particular?
Yes. So there are some exemptions, not for manufacturers or processors. But if you're not a manufacturer or processor, if your average gross annual sales in the US of cosmetic products for the previous 3-year period is less than 1 million, then you're considered a small business. In other areas regulated by FDA, again, I have to pull from those for inspiration because we don't have it all fleshed out. But they essentially want you to have it on file. Sometimes they'll ask you to submit a small business exemption in a lot of cases. And so you're providing your financial statements and documents to support that. And so you can have certain exemptions from, this is from GMPs and from registration and listing. So those are the cases where you can have exemptions. However, there are cases where exemptions will not apply. I'm going to read through them real quick. There's products that come in contact with the mucous membrane of the eye, injected tattoos, anything intended for internal use, think like mouthwash, anything intended to alter the appearance for more than 24 hours, where it's part of the intended use. So something that's like semi-permanent. So those are not able to claim exemption as a small business.
Okay, but these products are also more invasive. So
yeah, a little more risky.
Yeah, exactly. And are there any guidelines on employee training?
So it's really important in general when you're trying to push out to the team, like any new regulation that comes out, employee training is so vital. It is the foundation of everything. This falls under GMPs. FDA has entire sections on this in other industries of GMPs. So the first question that you're always going to ask when you're looking at GMPs is, do you have qualified individuals? Do you have a robust training program? Because ultimately, you can have all the procedures in the world. If your employees are not trained properly, it's not going to be implemented. So training is going to be really the key to success with MOCRA. Again, let's say you have your person fielding your adverse event reporting, they need to be trained and they need to know what they need to do. If you have a person that's helping with labels, they need to be trained and they need to know what needs to go on the label. Now, in this case, allergens, so we said that recalls were caused in the past by microbial. Get ready, they're going to start being because of allergens. If you don't list your allergens on there, because if they're not listed, someone can have a reaction, causes a serious adverse event. So you can kind of see how things are working together in there. Again, at this point, recommend doing a gap analysis of your current quality. preparing for possibility of inspection. So that's where the training comes in, making sure that your team is ready to go if there's any inspection. So those are kind of the things to think about when it comes to employee training. So absolutely, it's a very, very important part of the implementation, the practical part. You can read the law, but the practical part is what's going on in your facility, in your business, and do your employees understand, the significance and what they need to do to accomplish that.
Awesome. So we obviously need qualified individuals. We have to have a good training program.
Yeah.
Then just making sure that we are following GMPs and all of the other regulations as well. Sounds very easy.
No, not very easy.
And this is where my next question actually comes in.
Sure.
What about legal consequences for brands that are not complying with this? I know that right now we're still in this transition phase, right? But
Yeah.
once everything basically becomes effective, what are the consequences?
Yeah. So it's always important to look at that, right? Not here to fear monger or anything, but there are a couple things that can happen if you don't comply. Obviously, right now we're still very, very new, so it's still very early, but FDA has stated, we talked about the mandatory recall, putting your stuff in the public right there. That's a consequence. In the registration sector, you can be removed from the registration database. So that's another consequence. If you're not compliant, like I said, with the allergen labeling, things like that, you can have inspections that result in what's called a 483, where the inspector comes out, issues observations, you have X number of days to respond. And if you don't respond in the way they'd like you to, they can issue a warning letter. So that's the next thing. You can get a warning letter. You can just get a direct warning letter for not complying with certain things. FDA also has the ability, they have a criminal branch, fines, penalties, injunctions, all kinds of things there. And then finally, outside the realm of FDA, but still really important to consider as a legal consequence, are lawsuits. We see this a lot in the food industry right now. Tons of plaintiffs' lawsuits going on, especially around like labeling. That's also a possibility now with the allergen requirement and things like that. You're even required to list your allergens in your fragrance, which fragrance used to just be fragrance, right? Now you have to list any allergens in there as well. So those are the things that can happen. Those are the consequences that can come from not complying with this. So it's really important that as it's taking time for FDA to roll out these regulations, you're just keeping on top of it. Sign up for FDA's email list. They provide updates probably more than you'd like, but it's really helpful to know what's coming out, guidance document wise, regulation wise, all of that.
Yeah, I think that's a really amazing way to stay up to date. And I apologize for the background noise right now. How does MOCRA actually impact companies that want to advertise their products? In other words, does MOCRA also define how brands can make product claims like, the standard 90% reduction of the appearance of fine lines and wrinkles?
That's a good question. So within MOCRA, there's a definition of cosmetic. I think the claims aspect is going to kind of box it in. Does it fit the definition of the intended use? That's where FDA really regulates claims, is on the side of whether you is whether you fit within the category that you're supposed to be in, right? So are you making a claim that is a drug? Then obviously that's going to kind of fall under MOCRA because you're not meeting the definition of cosmetic. But in addition, there's also the substantiation part of claims and advertising, which is really important as well. I'm an FDA compliance attorney. I do also do some FTC work. Federal Trade Commission, they regulate the substantiation of claims, whether they regulate the truth in advertising. So that's also something to take into consideration, that is a requirement when it comes to claims. And then I think under MOCRA, like what we're really seeing is this is an increased amount of authority that FDA is taking over cosmetics. So you better bet that we're going to see stronger enforcement. You rarely see warning letters on cosmetics. I think that's going to ramp up because that's the tone that they're setting with MOCRA, is there's going to be stronger enforcement over claims.
And I know MOCRA is new, right? But do you have any examples, even outside of MOCRA, where a company was penalized for making false or misleading claims?
So yeah, there are a lot of examples. I came up with a couple because we usually like to share some case studies and some examples of companies who have kind of gotten in trouble for certain things. Without going too deep into it, for the sake of time, I came up with some examples. So this is one that I think Susanne will appreciate because of what Citruslabs does. So there's an example of a company, a wise woman who received a warning letter. They got into trouble for claims. The claims that they made started off with a 2016 study recently showed. Okay, so everyone's seen these claims before. That's great. You've got a study. In this case, the study showed that the ingredient in their product helped reduce inflammation and joint pain. So even though you've got a study, you're claiming that this study showed that the product could do what a drug is meant to do, right? To treat, prevent, mitigate disease or condition. So even though you have a study, it doesn't necessarily mean you can use that in your advertising. So it's important to really understand the claims that can be made. Here's another example. And they cited, in this case, their blog. I have a lot of clients, when they ask for their website reviews, they're like, oh, you don't have to worry about the blog. No, we have to worry about the blog. That's important. It's a form of advertising. Ultimately, it's on your website. It's next to your point of sale. It's important to consider the blog. So in this case, the blog said, a study showed that elderberry extract is effective in the treatment of flu. Elderberry, that's something I see everywhere now. But right there, they talked about the treatment of flu. What they're saying is a study showed this ingredient does that. What you're implying is, on my website, I sell something with elderberry. And so I'm trying to insinuate that I have elderberry in my product. A study showed elderberry can treat flu. A plus B equals C. My product can treat the flu. So that's what FDA is looking at, in these cases where, essentially where you're making these types of claims and where studies are involved. So studies are great. It's important. You need to have them, but there's a step one to that. So that was one example I wanted to give of like some false and misleading claims that came up.
That's very interesting. Yeah, I think ingredient claims are great, right? But then also, can you actually make these claims?
Right.
Are these allowed based on, are you then making drug claims? I think this is something that probably many people in the audience will be interested in. And then should cosmetics actually have clinical trials to then back up their claims?
So again, I think this is on the FTC side of things. And there's been a lot of, actually, Susanne and I were just talking about this before we jumped on the webinar, but the FTC rather did just release a health products compliance guide. I think it was around the same time as MOCRA. So it's still really early. But essentially it kind of broadened the scope on clinical trials, the types of backing that you need to have, right? Not specifically clinical trials, but on the type of backing. So I wanted to kind of give a little update from our last webinar, if you were there. So the guidance kind of expands on the amount of claim substantiation, like the type of claim substantiation you have to have, and it expands it to all categories of products making health claims. So it includes now supplements, OTC, cosmetics are included, everything, right? They're trying to level the playing field for substantiation. When it comes to health claims of all kinds, they want to see randomized controlled trials. You cannot rely on in vitro. you cannot rely on animal models. So this is something that's really important to consider when we're talking about, clinicals. And then the big question that's happening right now with that guidance is enforceability. So do we know if FTC is really going to enforce this stuff? Well, I can tell you on the FDA side, they're not as aggressive. The FTC is very aggressive. So let's kind of anticipate that enforcement's going to come earlier rather than later. And generally, to answer your question more straightforward, because I did want to provide that information, clinical testing of cosmetics and personal care products are really important when it comes to substantiation for packaging and for advertising. You really need to make sure that you have that testing done to support any claim. We'll go back to the beginning of the webinar. Any claim you make, you've got to definitely have something to back up that claim before you put it on there.
Okay. And then for cosmetics in particular, many brands opt for consumer perception studies and not clinical trials. So these are, relatively simple studies. They are not randomized control. This happens mostly because of budget. And what do you think about perception studies in order to back up claims?
Yeah, I mean, I think that they're great. They're valuable, absolutely. And, the good thing, like you said, from a cost perspective, they're good. I think it's important to weigh what kind of substantiation you're using for the type of claim that you're trying to provide. I think that's kind of built into, anyone who provides consumer perception studies is going to have an idea of what kind of claims you can make based on the study. So I don't think there's too much, danger there if you're going to, if you're going somewhere that specializes in providing these types of studies. One thing that I think it's important to be wary of that I've seen in some of these are the visuals that you provide. So like the before and after pictures. So for example, if you have a shampoo and you say it makes your hair fuller, which is it's fuller looking, right? We could say the appearance of fuller looking hair, and you have a picture of a person with a big bald spot, and then you've got an after picture of a person with that bald spot completely filled in. Ultimately, what you're giving the impression to the consumer is that it can grow hair, and that's actually a drug claim. So even though it's imagery, it can still be considered a claim. The imagery is a claim. And so what you want to think about is, what is your consumer thinking about what your product can do? And I think that that's something to really consider when you're doing these consumer perception studies.
So when, going back to acne, for example, when, I have a product and then it reduces the appearance of acne, that is a claim I make. And then I have before and after photo. Yep. In one photo, the person's face is full of pimples, and then the next photo, it's actually clear skin. So this would then also probably be more in the drug claim category.
Yeah, I think, I mean, if the idea is that it only reduces the appearance of acne, it's kind of hard to say that it went from a full face of acne, because it is technically a disease, right? Or condition, that it went to, a face that's completely clear. I would probably question like what kinds of ingredients are in there, and the idea is FDA doesn't want. So let's say you're treating your acne with an actual drug product, even if it's an OTC with salicylic acid. FDA doesn't want you to forego that treatment to now use a cosmetic that may or may not have that same effect. And so that's kind of the thinking that I would use in that case. It's a really good situational like example, because I see a lot of that. I have a lot of clients who do stuff in the acne space.
Yeah. And then, so basically from your perspective, perception studies are fine as long as the claims are in line with perception studies.
Correct.
Okay.
Correct.
And then let's talk about probably both of our favorite topics, influencer marketing. Is influencer marketing affected by MOCRA?
So I wouldn't say, the only thing I would kind of tie it to MOCRA is, again, that increased authority and increased enforcement priority on FDA's side. But it's really important to shift to the FTC side for this. They've stated that it's pretty clear that social media is going to be treated just like any other platform that you use for marketing. Advertising is advertising, so they're treating it the same. Brands are going to be held accountable for influencer messaging. We've already seen it happen. Kim Kardashian has received a FTC notice, an FDA warning letter, because of her influencer messaging regarding a drug product. So it is something that's really important when you're dealing with influencers. You want to have some guidelines that you provide to them on what they should or shouldn't be saying about the product, because ultimately, if you're paying an influencer to market your product, again, it's coming from your mouthpiece. So you need to have control over not everything that they say, but the general terms of what they can or can't say to make sure that they're not going outside the bounds of the category under which you're trying to sit.
And I think this is probably very similar to also website testimonials, right? Because it is my responsibility as a brand to actually also clear up the testimonials that are going after drug claims, right? If I have a product for eczema and somebody has written a review and said, this product cleared my eczema in 2 weeks, this is probably something, if I fall under cosmetic, this is something I probably want to delete. Is that correct?
Yes. And it kills me a little bit every time I have to, because I know that testimonials are gold. And I know that it takes a lot of work to get testimonials from people. And even if you're doing it like in the fairest of ways, and you're just letting people type in what they want, ultimately, if it's on your website, on your social media, you have control over what's being said. It's your job to make sure that there are no claims that are going outside the bounds. So again, the example you use is a great one. If you have a moisturizer, you don't want any testimonials where people are saying it healed my eczema, because ultimately those testimonials, the reason they're gold is because they are a form of marketing. It is a way for you to get business. So if you're trying to get business, by using the fact that someone said it cleared their eczema, that is a tactic that you're using. It is ultimately your responsibility to make sure that that claim is not, on your website, on your social media. That is your job to do so. So the rule I use, anything that comes from the brand's mouthpiece. Now, if someone on another website that you don't know had, collected testimonials, that's not your problem. But if you then want to take those testimonials, use them on your website, that's when it becomes your responsibility to then make sure that you're looking through and kind of sanitizing those. And you can modify testimonials as long as you're not changing the overall meaning of the testimonial. You can make some changes. So like use a little ... ellipses. I do that for clients all the time when I do, especially website and social media reviews.
That is really great advice. And actually, Heather created a little doc for you all where all of the important key points are summarized. So now your chance to take a photo, scan in the QR code before we go into the questions. And I see that we already have actually quite a few questions, which is awesome.
Do you mind giving me one moment, Susanne? I need to grab my charger. I apologize.
Of course.
I forgot to plug it in. Just 1 second.
Yeah. Okay, so your chance to ask questions comes very soon. Just download the key points. And once Heather is back, we can continue with the Q&A. And obviously there will be a recording that is going to be sent out. And Heather is coming back, which is awesome.
Thank you, guys. Sorry about that. I was so excited. I forgot to put in my charger.
Don't worry.
All right, I'm excited. Let's do this.
Okay. So first question, to clarify, brands need to be registered with the FDA by the end of this year. Is that correct?
I wouldn't use the term brands. I would say manufacturers. manufacturers and processors. And the registration is of your establishment. And then you're also going to have to do product listings. So that means, and FDA does have a framework for this in the voluntary system. I've done quite a few of these, mainly because Amazon requires it, not for any other reason. But so essentially you register, you put in all the information of the establishment, and then you go in and add the information on the product. So things like your label, the name of your product, the amount that's in there. So kind of basic information. But what FDA is trying to do is get together a database. And we think what we're predicting is that there's going to be some fees associated with registration. I think they said it's a biennial registration. That's important to note. On the food side, they have biennial as well. That means every 2 years. On the food side, it's every 2 years, even numbered years. So for example, if you were to register for the first time now in 2023, you would renew it in 2024, but then you wouldn't renew it again until 2026. So it may take that same form where it's on even numbered years. But the biennial part is great because it's every 2 years versus every single year annually. And then you will have to make updates to your product listings. I believe it said within 60 days of any changes made. So if you change your label, you'll have to submit that to the database as well.
Okay, and that is in the next question is in basically the same topic. So if brands use a third-party manufacturer, then brands need to comply with everything and need to work with manufacturers that are actually registered, correct?
Absolutely. So yeah, be in contact with your manufacturer, and you'll have to give them the information. It's going to have to kind of go through multiple parties, right? If you are a brand owner. So if you're a brand owner, you're most likely in charge of your label compliance, not your manufacturer. Even if your manufacturer is printing the labels, you're still the one responsible for the content. So it'll have to go through you first to get the label created, make it compliant, then send it over to your manufacturer, who will then update the product listing. And that all depends. In the case of drugs, they do have the ability for brand owners to have their own product listings. I don't know if that's going to be the case here. I believe that it's going to be only manufacturers who can have the registration and listing. And so absolutely brand owners are going to have to work hand in hand with their contract manufacturers to make sure that the listings are updated.
Okay. And can you repeat again what the amount of sales is that classifies a small business for exemption?
So to qualify for the small business exemption, the number was, hold on one second. It's 1 million, less than 1 million over the previous 3-year period. So each year. And that's in annual gross sales, average annual gross sales. So you'll take your gross sales of the last 3 years, average that out, only of cosmetics. So if you work with other products, focus only on the cosmetics, average that out. And if it's less than 1 million per year for the last 3, like over that 3-year period, then you can qualify for the small business. Again, I don't know if they'll require you to submit. That is likely that they'll require you to submit that information. So it's good to start gathering that if you do intend to take advantage of the exemption.
Okay. And if a cosmetic with sunscreen is already registered with the FDA as an OTC, does this brand then also need to register under MOCRA as well, or is it all set?
So if it's just a straight, can you repeat what the type of product was? Was it just a sunscreen?
Sunscreen.
Just a sunscreen?
A cosmetic with sunscreen.
Oh, if it's a cosmetic with sunscreen, yes. If it's just a sunscreen, no, you're fine on the OTC side. So it depends on the types of claims that you're making. So like we gave an example of a moisturizer with SPF in it. That would be both. That would be a cosmetic and a drug.
Okay, and then we need to register it again under MOCRA.
The manufacturer would.
The manufacturer. Okay.
Yeah.
That makes sense. And then you also mentioned earlier products with mucous membrane. And one question is if eyeliners actually fall into this category.
If it comes in contact with the mucous membrane of the eye, I would think that eyeliners would fit that definition. That's my my gut would tell me that.
Okay. And are there any regulations being implemented in regards to ingredient labeling?
Yes, so like I said, one is going to be the allergens, making sure that you're listing your allergens. They're likely going to use the same allergens from the food side. So for example, I just had a client who has a shampoo that has like walnut shells, and I'm like, hey, just to start anticipating this, if you're going to be printing labels, let's add the contains walnut on there, just to be ready for it. So that is something on the ingredient side. And then the substantiation is another big change. Like I said, you need to work with your ingredient suppliers. If you are an ingredient supplier, get up to date with what kind of substantiation from a safety perspective. There's a lot of companies that do this, the safety testing, and get with them and, make sure that you have those documents on file. And what's going to start happening if you are an ingredient supplier is the companies who you contract with are going to start asking for that. They're going to want it on their CFAs. They're going to want to know that you have the substantiation so that they're not getting in trouble, later downstream.
Okay. And then also with, allergens, one question was, if, for example, soy is clearly listed on the ingredients, do you also have to call it out against allergen information somewhere else on the label?
So I don't think we've fleshed this out yet with MOGRA, with the legislation, but if I'm using the food as an example, they do allow you to do that, where you could, if you list it in the ingredient listing, that you don't have to have a separate contained statement. I'm not really 100% sure. In the case of that client, I wanted to make sure that they're prepared and that and she's on the conservative end, but it's hard to tell yet what exactly they're going to do. For now, I'm just using, other examples as inspiration for how to start preparing for that.
Okay. And then a lot of questions again around small business exemption. Are you, when you qualify as a small business, are you then exempt also from all of the other rules under MOGRA?
You're only exempt from GMPs and registration and listing.
GMPs and registration.
That's my understanding, is what that applies to. Okay.
Well, we have a lot more questions. Let me quickly we have a couple of questions also, for testimonials and also reviews on websites. How far do brands need to filter? How far back do they need to filter in terms of reviews, testimonials on websites?
I mean, something I tell clients is like, there's the rule and then there's how well you want to follow it, right? Like everything's based on how conservative you are as a business. I mean, ideally, you'd like to get rid of any and all claims that are in violation. But I know that that's hard. And it's the same thing with social media. Like that can be hard if you've been in business for a long time. There have been cases where FDA will go through and sift through everything, regardless of when it was posted. So yeah, to be safe, if I'm going to say the most conservative approach is just remove whatever violative content you have on there. But ultimately, that's a business decision, I think, as with anything in compliance. Yeah.
And then I think one question in the same kind of realm of claims, reviews, and social media. How enforced is content claims on social media like TikTok and Instagram, and how regulated is that? I think you already mentioned that now everybody cracks down on influencers. So yeah.
I mean, it's slow moving, but it's happening, right? And with anything with compliance, there's always like levels of risk, right? I think when it comes to like social media and stuff, so if we're coming from like a risk-based perspective, if you are complying with, everything else, right? Your quality is on point, you're GMP certified, you got, I mean, if everything else is on point and you have, one influencer making the wrong comment, that's a very low risk. FDA is not going to put the manpower there. But if you feel that there's a lot of red flags and there's a lot of things that you need to work on, and then you also have influencers pushing out, stuff, and you have social media that has all kinds of claims, then obviously the risk level is higher. So it's a little bit situational. It all depends. That's something that I do with my clients. I like to holistically look at their business and the different streams that they have for marketing and kind of determine like what's the level of risk, and provide, alternatives if there's alternative ways to do things. So yeah, I think it's very situational in my opinion.
Okay, and I know we're way over time, but I want to wrap it up with one question that I think is really interesting. What about Amazon or other retail testimonials? Is this something that brands need to control?
My understanding is yes, but Amazon has not been previously. When was it? A few months ago, FDA just recently issued its I don't know if it was its first or second, but it was a big thing, a warning letter to Amazon directly as a third party, and then issued warning letters to the companies that were also making the posts, or not making the post, but who had their products on Amazon. So they did like a two-prong approach. They did it towards Amazon as the third party, and then they did it towards the companies as well. So I think, again, it goes back to like, how conservative are you as a brand? If your entire business is based on like a violative claim, that's a really difficult position to be in. If your moisturizer has always been known to treat eczema and all of your stuff is covered in those claims, like, yeah, that's a difficult position. But ultimately, if you want longevity of your brand and you want to avoid, like I said, not just FDA, lawsuits, FTC, national advertising, like there's a lot of things that can happen, then it's best to try to do as best as you can to remove that content.
Okay, well, that is super useful information. Thank you so much, Heather. That
Of
was very
course.
insightful as always. And thank you so much, everybody, for tuning in today. I hope you all learned something about the new FDA guidelines, MOCRA. We also tapped again a little bit into the FTC guidelines and how it affects your brand. And if people want to get in touch with you, Heather, how should they reach out?
So if you'd like to just schedule like a 15-minute chat with me, you can go to our website, bustoslawgroup.com, click on free consultation, and it'll actually allow you to schedule with my real-time availability. If not, you can email me. It's hbustos, so H for Heather, Bustos, my last name, Bustos, at bustoslawgroup.com. Just shoot me an email, and we can get you scheduled for a quick chat as well, so we can kind of talk about what your needs are.
Awesome. And you can reach out to Citruslabs on citruslabs.com, or by sending an email to either hello@Citruslabs or to Susanne@Citruslabs. Please note that my name is spelled Susanne. And thank you so much for attending. Our next webinar is titled Lab to Label, the key for building trust and preventing consumer skepticism, in which we will explore best practices for making product claims and how to build trust and credibility with your target audience. We will have a couple of brands speaking, and Heather will also participate.
Yes,
Well,
we need a lot more time for questions, I think.
Yeah.
We always end up running out of time.
Yeah, I know. We have 27 more questions that are unanswered,
and they're good ones.
For it.
They're very good ones.
Yeah. Okay, well then, thank you very much, everybody, and I hope to see you next time. Thank you.
Bye.
Bye.